As I mentioned earlier, a bond was to assure somebody's presence in court. You couldn't do anything to a person without a trial. And the person had a right to an attorney, had a right to be free from forced confessions, illegal searches, had a right to confront his witness, had a right to a trial by jury. All of those were incorporated in a concept of what lawyers and political scientists call due process. So the police's job is not to go out and protect everybody from the apocalypse. The police's job is to gather evidence and not judge on the evidence, just gather the evidence and present it to somebody to evaluate. Typically referred to as a magistrate, which could be any judge or whatever. And then the magistrate is supposed to go through it and say, okay, you did this, this, and this, and that's good, but you didn't do that, and you screwed that up. You don't have a case. Well, the cops started construing that as a slap on the wrist. You would hear cops bitch about, I worked my ass off getting this guy or that guy, proving and getting him put in jail and getting them arrested. And then they get a slap on the wrist and they're turned loose. And the ignorant press starts printing this. And the implication is they're out to roam, they're going free, etc. And the police's affront by the judge setting a bail or turning somebody loose on bail becomes an affront to justice when they follow the cops' complaints about turning criminals loose and not punishing them and not protecting the public, etc. So there's a principle in the Napoleonic Code. In the Napoleonic Code, you don't have a right to presumption of innocence. Once you're a bad guy or adjudicated a bad guy, you're always a bad guy. And you didn't have rights to trial by jury, all kinds of other rights. And if you were suspected of committing an offense, they would lock you up until the inquisitor made inquisition to determine whether or not there was an offense or crime. So, continental Europe and the Roman law, Napoleonic Code, had inquisitions where they would inquire into the facts around a certain situation or case. Under the American system, or under the English system, a person was accused, and he was presumed to be innocent until proven differently. There's a big concept or contrast or difference in the frame of reference. Now, young prosecutors are taught in law school that there are certain due process things that are necessary in our system and necessary to make it work. And they take their job seriously, and they want to do good, and they want to please the people that they're allegedly representing, and they forget they're representing the people. They think they're representing the police officer. And when the police officer loses a case or complains about it, or this, that, or the other, complains about a judge, we've got a bias in the system. And what happens then? We load the system up because nobody has the balls to say this is wrong, this is against the Constitution, or any number of things. So soon you get prosecutors arguing in front of judges about the revolving door and about slapping the wrists and things such as this. You've also got legislation now where prosecutors can argue somebody might be a flight risk or a danger to the community or any number of such things. And wherein there are no standards, there's no measurement. It's all arbitrary, capricious, depending on the political orientation of the judge and the political orientation of the prosecutor. And the idea of justice, the idea of fair trial, the idea of presumption of innocence, the idea of facing your accuser, or even right to counsel, goes by the wayside in the name of expediency. So, this is one of the great debates going on in the legal profession. I can remember a case that I had once. He was an alleged mafioso, and he was charged with transmitting or transporting stolen securities across the state line. The prosecutor had offered a disposition or a deal where if I pleaded him guilty to that, he would cap the prison sentence at 12 years. Well, my guy had been in prison for another offense. He was out on parole. He was trying to go straight. He was looking for jobs. And he begged people for jobs occasionally. He was a fairly decent chef. And he cooked at a country club. And he had this girlfriend. Well, the girlfriend had an ex-boyfriend who got arrested. And she had made a deal with the feds that if she caught a criminal, her boyfriend could go free. And they targeted my client. So she moves in with my client. And she was working at a bar that the FBI set up that they named Scotland Yard. And it was an FBI sting operation. So for a year, my client would come in there, and he got friendly with the FBI agents that ran the bar. And he kept saying, give me a job, let me cook, let me do this, that, or the other. And they'd say, oh no, Joe, you're meant for bigger things. Go steal some securities or this, that, or the other. So after about a year, he found that there was a high-stakes backgammon game in California and asked these FBI agents, posing as bar owners, to stake him. Well, they said they couldn't stake him and that he had experience in securities. So why didn't my client take these securities that somebody had got from a pawn shop, take them to California, and get a stake by fencing them to a person that they would introduce him to. And then he could have the money, and if he won a backgammon game, pay it back, etc. So off trots my client to California. Next thing you know, he's indicted for interstate transportation of stolen securities. The whole operation and thing was schemed and set up and played out by the police, by the FBI, in a sting operation. They had a special grant for it. I looked at the grant application. It had nothing to do with people like my client. The sting operation was an elaborate scheme to set up politicians in a certain jurisdiction to see if they were taking bribes. They didn't get any, but they did able to bottom feed and troll some poor guy on parole that they could entrap into committing this crime. So, with nothing to lose, I go to trial. The prosecutor puts on his evidence and stops about noon on Monday. I finish up the case on noon on Friday. Sometime maybe I'll get into the detail, but I showed a lot of psychological stuff, a lot of misconduct pretty much by the FBI, uncontrolled sting operations, etc. So, since the guy had a prior felony of interstate transportation, the judge said, well, it looks like he's guilty, but this, because of a certain case, I have to find him guilty. But it's a chicken shit case. So he goes through it and said that he opened his sentencing ruling by saying, Mr. Blewett has cast a spear into Hampton versus United States, which was a famous entrapment case, and spells out what was wrong with applying Hampton, why he had to apply Hampton, and ended up putting my client on probation. So the FBI agents got really pissed off over that because they thought they busted their asses working in this bar on the sting operation to get a defendant, and they get the one defendant and they prosecute him, and they spend all this time at a trial, and a judge puts the guy on probation and chews their asses out. So after the case, I'm out in the hall with my client, and I hear one FBI agent say to the other, he said, I wonder how much that fat bastard paid the judge for that result. Well, the judge's law clerk heard it. And my client, when he found out even though he was convicted, that he was put on probation, almost broke down in tears because he'd never been put on probation on a case before. We get down on the elevator, go to the first floor, and one of the U.S. Marshals, whom I knew, came up to me and said, Dennis, the judge wants you back up in the courtroom. Well, my client about shit his pants, and he thought, oh God, he's going to change his mind, he's going to throw my ass in jail. Started quaking and things like that. So we go up the elevator to the courtroom, and the judges called me into chamber. And I'd known the judge when he was in private practice, and we'd done some cases together. And he wasn't exactly a friend, but he was a good acquaintance. In fact, when I taught criminology at University of Colorado, he would come and lecture my classes. Anyway, he said, Dennis, what happened after the case when you guys left the courtroom? And I said, I don't know. What are you talking about, Judge? Well, what happened? What happened out in the hall? What was said? Did the agent say or do anything? And I said, yeah, one of them made a comment about my weight problem. And the judge looks at me and he says, Dennis, don't bullshit me. I know what went on, and you better tell me, or you're going to be in deep shit. So I said, well, the one FBI agent commented to the other one that he wondered how much I'd paid you to get the result that we got, which is exactly what the clerk had said. He looks at the two FBI agents, said, is that true? The FBI agents, being beat red, said yes. The next thing I knew, the FBI agents were being sentenced to jail for contempt of court. So here we had a mafia case where my client gets probation and the FBI agents get a jail term for contempt. But that is a good example of how things get out of proportion. Like the Gilbert in Le Miserable. Under the French system, once a criminal, always a criminal. Once you get the label, you're always labeled as a criminal. And Gilbert ended up jumping off a bridge because he couldn't reconcile his construction of reality with what he had seen. Because with Jean Valjean, he turned out to be a good guy rather than a bad guy. And the police prefecture figured he should be a bad guy because that's what the law says. So these are some of the changes that went about under the Nixon administration that I'm going to delve into a little bit more.